The Spousal Trust. A spousal trust is a sophisticated estate planning structure designed to provide for a surviving spouse, often from a second marriage, while preserving the capital for the ultimate beneficiaries, oftentimes being one's biological children, including those from a prior marriage. Established either during a person's lifetime, inter vivos, or through a will, testamentary, it allows for the seamless transfer of assets without triggering immediate tax consequences. To qualify under the Income Tax Act, must ensure that the spouse is the only person entitled to receive all the income generated during their lifetime. This legal structure is particularly common in blended families, where a grantor wishes to support their partner while ensuring that the remaining inheritance eventually passes to their own children. One of the primary advantages of a spousal trust is the tax-deferred rollover of assets. When an individual transfers property to a qualifying spousal trust, the transfer generally occurs at the adjusted cost base, meaning no capital gains taxes are paid at the time of the transfer. This allows the full value of the investment or property to continue growing within the trust environment, rather than being diminished by a large tax bill upon the grantor's death. However, it is crucial to note that the tax is merely deferred, not eliminated, as the deemed disposition occurs upon the death of the surviving spouse. To maintain its qualified status in Canada, the trust must adhere to strict operational requirements throughout its duration. Aside from the income distribution rule, no person other than the spouse may receive or obtain the use of any of the trust's income or capital while the spouse is still living. If the terms allow for payments to children or other relatives during the spouse's lifetime, the rollover benefits are forfeited and the assets are taxed as if they were sold at fair market value. These rigid criteria necessitate very careful drafting by legal and tax professionals to avoid accidental disqualification. Beyond the tax benefits, spousal trusts offer a high degree of asset protection and control for the grantor. By placing assets in a trust rather than gifting them outright, the grantor can dictate how the remaining capital is distributed after the spouse passes away. This prevents the surviving spouse from diverting the family wealth to a new partner or different heirs, which provides significant peace of mind in complex family dynamics. Additionally, because the assets are held by a trustee, they can be shielded from certain creditors or mismanagement if the surviving spouse lacks financial expertise. Finally, the administration of a Canadian spousal trust involves ongoing compliance, including the filing of annual T3 trust tax returns. The trust is deemed to have sold all its assets at fair market value, and the resulting tax liability must be settled before the remainder is passed to the residual beneficiaries. Despite these administrative complexities, the spousal trust remains a cornerstone of Canadian wealth preservation for its unique ability to balance immediate spousal support with long-term legacy planning. To learn more about our estate planning legal practice, we welcome you to visit our website and contact our law firm to schedule an initial consultation. Thank you.